This morning's arguments with case number 18CA0085M, In Re, MD, and PC. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. I don't know if you've argued with the clock on the wall before, but we've added that feature so you can sort of keep track of where you're at in your arguments. If you do want to reserve time, though, let me know and I'll try to help you with that as well. These oral arguments are recorded. They're also posted on the court's YouTube channel, so we ask that you refer to children by their initials only. That's the rule. And we've read the briefs and we're ready to proceed if you will.
Your Honors, good morning. Eric Hall on behalf of the appellant Phil Cubic. I would like to reserve 5 minutes of my time for rebuttal.
5 minutes, thank you.
Your Honors, this is a difficult case. The result of a 4-day hearing on Abilene motion for permanent custody. The trial court judge granted that motion, granting permanent custody of the two children, MD and PC, to Abilene, and terminating Mr. Cubic's parental rights. It's a difficult case, Your Honor. If you go to the factors of RC 2151.414, the trial court's decision to terminate his parental rights, the appellant's parental rights, was against manifest weight of the evidence, not in the best interest of the children, and an abuse of discretion. And I understand that the trial court's faced with difficult decisions on these type of cases. Okay, but this resulted in its, as case law states, basically the termination of parental rights in domestic cases, equivalent of the death penalty. So Mr. Cubic, who's here today, it's very serious, and he was working toward reunification in this case. He had significant difficulties and obstacles in this case, which made it difficult for him. He was released from prison. He had established a very good bond with PC, but with MD, the older child, the conditions of his post-release control created an estrangement from that child, which made it difficult. He was only allowed limited supervised visitation. So I think the trial court gave undue deference to some of the statements that that child made without understanding the level of estrangement that Mr. Cubic had because of the conditions of his post-release control. He was trying to establish a close bond with that child. But with the other child, PC, he had a very close bond, Your Honors. But like I said, once again, the rules of post-release control and Peter's ability to spend more time with both children. Okay. He was progressing with this case plan, albeit not at a rate that maybe the appellee would have wanted. But once again, he faced significant difficulties. The case, I know this is about the father, Mr. Cubic, the appellant, but he had no assistance from mom at all in this case. So he was doing everything on his own. He was able to obtain a stable and safe home for the children. But one of the problems in this case, as I read through the transcripts, was there seemed to be several personality clashes between the appellant, Mr. Cubic, and the caseworkers. Keeping these things in mind and putting them in a proper perspective, Your Honors, this should not have had any effect on his ability to attain the goal of reunification in this case. These were the difficulties between Mr. Cubic and the caseworkers, but they shouldn't have impacted his ability to establish closer bonds with the children, to proceed with the case plan, and to receive more assistance from appellee. What I get to reading the transcripts, it seemed to me that the appellee, the caseworkers, just dug their heels in on this case against Mr. Cubic. And under those circumstances, that's why they proceeded and they took this position in the 4-day hearing, moving forward to seek permanent custody. And I think the trial court, and listening to the testimony, gave too much, I believe, deference to some of the difficulties, the personality clashes that Mr. Cubic had with the social workers. That has nothing to do, Your Honors, with his relationship with the children. And I think the trial court abused its discretion in making in the decision in this case by focusing too much on that evidence, which really, in my mind, is not relevant to whether reunification is a possibility, that didn't happen, Your Honor.
Remind me, was the, one of the conditions of parole to have no contact with MD?
I believe that was, and there was a domestic violence charge that Mr. Cubic pled guilty to.
Now, when was the post-release control scheduled to end then?
Your Honor, I'm not sure, but I think it could have been modified. My understanding, in speaking with Mr. Cubic and also reading the transcript, that there's a possibility to have those conditions modified. But I think there needed to be some input from the appellee in doing that. And Mr. Cubic needed some help with that. I mean, I believe he wanted the conditions modified, but I think because children are involved, and the modifications would have involved the children, that the appellee would have had to have some input into that with post-release control, the adult parole authority, in order to make that happen. I don't think that happened, Your Honor. As far as the domestic violence charge, this was an incident where the older child had hit the younger child in the head with a toy truck and hurt him. Mr. Cubic used what I would consider reasonable parental discipline. He used a belt and unfortunately left a mark. This, in my mind, Your Honor, and I didn't represent him on this case. We pled guilty to it. This is not domestic violence. It sounds to me, absent any other type of injuries, that somebody leaving a mark on a child, belt spanking, for something as serious as hitting another kid in the head with a truck, which the younger child could have been seriously injured, permanently injured. That's not unreasonable. I can't turn back the clock on that conviction, but I think that was unreasonably held by the trial court against Mr. Cubic.
Well, counsel, how, he pled guilty, he's convicted of this. How do we go back, like you said, you can't turn back the clock?
Oh.
And how could the court not consider that? How would that not be a statutory factor in regard to?
No, Your Honor, I don't want you to misunderstand. I'm not saying the court shouldn't have considered it at all. But I think if you listen, the facts of what happened, I think the court should have taken that and said, well, understand what happened. He entered a plea of guilty, no contest to this. But if you look at the facts, it wasn't as serious as it sounds, domestic violence against a child. It was in an act of parental discipline, which Mr. Cubic was reacting to a situation that some type of parental discipline had to be imposed at that time.
And what evidence was presented about the facts of the domestic violence?
I'm sorry, Your Honor.
What evidence was presented at the hearing regarding the domestic violence?
I think just basically at the motion for permanent custody, just the fact that this was the older child hit the younger child in the head with a toy truck, and then Mr. Cubic had hurt him, and then Mr. Cubic had imposed parental discipline by using the belt. I believe the older child had moved out of the way and had caught maybe the buckle part of the belt, and that's what happened. So it wasn't intentional.
Who testified to it?
I'm sorry, I'm not sure, Your Honor.
I just wondered if it was Mr. Cubic.
I believe we did, Your Honor. We did. But once again, once that conviction, that domestic violence conviction, that had a serious impact, I believe, in the eyes of both the appellee and also the trial court judge in this case, Your Honor.
Was the domestic violence conviction the thing that prevented the parole board from letting him visit with the son, or was it that other felony?
I believe it was both factors, Your Honor. And in order to get the parole authority to modify that, this was something that was beyond Mr. Cubic's ability alone to do that. Either counsel representing would have had to do that, or counsel representing would have had gotten together with the attorneys for Job and Family Services, the appellee, and said, okay, what can we do about this, and how can we get a modification? It's a reasonable modification and still protect the children.
Well, did the parole board have the authority by law to be able to do that?
I believe so, Your Honor. I believe they can make a modification on conditions of parole, but for a parolee to do that, it's not that easy, especially in the circumstances. Like, as I mentioned, he has significant difficulties. One, he's trying to follow a case plan. He's trying to obtain stable and safe housing. He's dealing with a mom who, for lack of better words, was no assistance at all in this matter. And that came out of some of the trial where he was admonished for making comments about the mother. Essentially, the trial court said he was attacking her, but The mom was not of any assistance in this case when Mr. Cubic could have used some assistance from the other parent, and he didn't get any. So he's doing this all on his own. Everything was on his shoulders, Your Honor, and it was quite a bit. And what I'm saying is that the trial court should have gave some deference. I think, and looking at the rights, the best interest of the children, Mr. Cubic was trying. He was trying, okay? And I think the trial court didn't take enough of that into consideration when the trial court made its decision in this case after 40 hearing honors. Do you have any other questions?
Okay, you'll have 5 minutes then?
Yes.
For rebuttal.
Thank you.
Thank you. Counsel, you'll have 15 minutes.
May it please the court, my name is Amanda Casanova, and I represent Medina County Job and Family Services. In this matter, a complaint was filed on December 10th of 2015, alleging abuse, neglect, and dependency of MD and dependency of just PC. The agency had received these children via Juvenile Rule 6 due to MD appearing at school with multiple marks and bruises sustained and reported by father. The shelter care hearing was held the next day, December 11th, 2015, and such was granted. Adjudication was February 23rd, 2016, where both children were adjudicated in neglected and dependent children. Since then, the children have remained in the agency's temporary custody. The basis of the agency's motion for permanent custody was filed under 2151-414B1D, in that the children have been in the agency's temporary custody for 12 out of 22 months. At the time of the permanent custody hearing, since the date of adjudication, the children were in the temporary custody of the agency for approximately 21 months. I believe according to father's own brief on page 7, he does not contest that the agency met this first prong and its burden for this first prong. However, father does raise the trial court and properly found that permanent custody was not in the children's best interest. Best interest factors include relationships, wishes, custodial history, legally secure placement, certain enumerated E factors, and in this case, trial court considered all factors as required by statute and law. First off, the court considered those relationships with parents, foster parents, caregivers, relatives, non-relatives. The trial court ultimately found that the significant relationship here was between the children and foster parents. And some of the testimony that supported that finding was MD's therapist testified that the child's mental health progress on his PTSD was due and attributed to foster parents' involvement with the children. They created structure for the child among all of his environments, so at home and at school, creating boards for rewards, for good behaviors. This saw progress in the child's mental health. In fact, child MD had a part in this. MD had, during a session with his therapist, identified his family in the picture as foster parents, the foster family dog, and his younger sibling who resides with them. However, father's relationship in this case was much different. Due to father's convention of domestic violence against MD and rules of supervision, father had a no contact order with MD. Father has not seen this child since December 10th of 2015. Father's parole officer testified at the court that his projected release date would be June of 2019. However, his relationship with MD was non-existent, but it was also complicated with PC. Due to father's sexual-related offense and rules of supervision because of the domestic violence, father cannot have unsupervised contact with minor children, including his own child, PC, and a supervising adult has to be approved by the parole officer. Father's parole officer went on to testify that it would be violation behavior and unrealistic if the child lived with father. Father himself called in his case in chief over 5 relatives: paternal aunt and uncle, a maternal grandmother, and paternal grandparents. They all testified about their bond with the children, how much they love the children. However, all of the relatives also testified that they believed permanent custody to be in the best interest of the children, and that the children should remain where they are. Most relatives, including mother, spoke about the child ND years ago, that ND used to be a scared child, but today he's happy and he's smiling. And those relatives attribute that to him feeling safe at the foster family home. One of the most sincere moments in this trial was when mother was called to the stand by father. And although father testified that he wanted to embarrass her that day, she testified that terminating parental rights would be in the best interest of the children, despite the love she has for them. She acknowledged that herself and father didn't do a good job being parents to the children. However, the most notable relationship in this case is the relationship between the children. Caseworkers, foster parents, therapists all testify to the bond with the siblings. They tell each other that they love each other and they are constantly looking out for each other. Next is the wishes of the children. Father suggests to this court in his brief that both children wish to be with him. However, that is simply not the case, and even the guardian ad litem was puzzled by this in his brief. Not only did the guardian ad litem recommend permanent custody to the agency for both children, it was very clear that ND communicated his wishes not only to the relatives, the guardian ad litem, caseworkers, non-relatives, therapists, of his pure rejection of returning to mother and father. ND in fact reported to his therapist that because father hurt him and his mother, he deserved to stay in jail for the rest of his life. The guardian ad litem had testified in his examination that he believed in his conversations with Michael, MD, that that the child understood the termination of that relationship. As to PC, it was expressed to the guardian ad litem that he had voiced the same. However, the guardian ad litem was a little hesitant here because of the child's age, but felt that permanent custody was also in the child's best interest. However, PC had expressed moments of details to his therapist that he would be sad if he lived with daddy visits all the time. Next, the court considered custodial history. Children were moved on December 10th, 2015, and remained into custody until the permanent custody hearing, which was in July 2018. That's approximately 31 months. Next is legally secure placement. There were no relative options in this case. Maternal grandmother would not complete drug screens. Paternal aunt would not take legal custody because she didn't want to deal with dad. There were non-relatives in this case. They were friends of father. Father described their relationship with the children as once in a blue moon. The child ND expressed fear to the guardian ad litem about living with them due to the fact that they were father's friends. Multiple witnesses testified throughout the trial about the poor housing condition with animal feces and vomit throughout the home. But most importantly, I think the trial court had serious concerns about these friends of father. In the trial for permanent custody, both husband and wife, the Normans, testified that they didn't know that father was convicted for domestic violence for hitting MD with a belt multiple times. And without knowing that, Mr. Norman testified that he believed father was wrongfully convicted. The trial court found this concerning. Father suggests to this court that he was progressing with his case plan, despite the obstacles the agency and the trial court put in front of him. However, father's case plan progress, or lack thereof, may be considered relevant by the trial court, but not dispositive. After 31 months of the children in custody and his case plan efforts, father still has a no contact order with ND and cannot be unsupervised with PC. Reunification is simply not possible.
How do you address Mr. Hall's contention that the agency should have done more with the probation?
I disagree, Your Honor. Testimony at the trial supports differently. Randy Fike was the first ongoing social worker in this case. He actually communicated with the parole officer at that time, who directed him to the victim's services liaison, and who he wrote a letter to with the support of the agency attorney at that time, Ms. Moore. That was rejected. Cindy Kohler was the second ongoing worker. Mr. Fike just left the agency on his own will. She sent 2 letters to the parole board, one in August of 2017 and one in September of 2017. However, there's no testimony in that transcript that father made any effort. But the agency sure did. There are specific enumerated factors in this case that the court did consider, that being E6, the conviction of domestic violence under 2919-25A against MD. However, the trial court noted concerns with father's testimony regarding this factor. Father testified at the hearing that he would do it again, as he had received much worse as a child, that he felt that he had the right to. The trial court, in its opinion, observed his testimony to show no remorse. And in fact, father's words verified testimony from PC's therapist. PC, during a therapy session, had told his therapist that father wanted to spank his sibling MD again. Father's behaviors and statements at the trial court hearing surely did not show a father who had made progress on his anger and violence since the day of the filing of the complaint. As in the trial court's opinion, he shifted responsibility. The child's behaviors were not because of what he did to that child, but because of what mother did. He spoke only negatively about mother at the trial. The court had to take multiple recesses to scold him for his behavior, actually had to move mother to a different table because of father making derogatory comments to her. The court had to take a break for a whole day because father came back from lunch under the influence of alcohol. The trial court found that he only cooperated with MCJFS on his own terms. During Randy Fike's time, the first ongoing social worker, father at times would comply with drug screens, and others just plain out refused. He was very aggressive and confrontational. During Vicki Messenger's time on the case, she was the third ongoing social worker, he constantly called her words. Father would not disclose employment. It's none of her business. At one point, the court found him contempt of not clean hair follicle, and then he had an OVI in later 2017. He continued to screen positive for marijuana in the SAMS program, and there was constant issues with verifying visitation with the children. At one point, the agency attempted to make sure that the visit was being properly supervised, there was properly sleeping arrangements and food in the home. Worker was refused to allow access to the home. Instead, father brought chicken nuggets to the door. So the next day, worker took out a police officer and was able to see the home. Unfortunately, when she turned back to the office, she had an email laced with derogatory terms, not welcoming him back to that home. At the time of the hearing, father was not seeking reunification. He wasn't seeking legal custody. At the time of the hearing, he testified he does not feel he should be custodians, rather than Normans. Even his own attorney at the trial court placed on the record that he was not seeking custody of the children during the objection. And again, when father was recalled at the end of the trial, he again indicated he wasn't seeking custody. Today, the agency is requesting that this honorable court affirm the trial court's decision granting permanent custody of the children to Medina County Job and Family Services. Thank you.
Let's see if there's questions. One of the things you noted in your brief, you state if an agency is able to establish any one of the 414D factors, it's in the best interest of the child to place the child into permanent custody. Is that your position?
That is not my position. Perhaps it was an error.
Am I reading that wrong, or? Let me just read what it says. If an agency is able to establish any one of these factors, referring to the 414Ds, it is in the best interest of the child to place the child into permanent custody of the agency. It's not a correct statement, is it?
That is not a correct statement, Your Honor. I would take that's an error. I'm sure I was referring to 2151-414, the B's, A through D, indicating. But absolutely, Your Honor, the best interest factors should be weighed, all five of them.
All right. Thank you very much for your.
Thank you.
Counsel, you'll have 5 minutes.
Thank you, Your Honors. This is a case where, once again, the trial court placed too much deference on the relationship the children have with the foster parents. Foster parents' rights should not have superseded the appellant's rights in this case. I don't think it should be relevant or given too much weight that the fact that the children are with the foster parents day to day. The appellant's under all these restrictions that he can't see one child, and he can only see PC under limited supervised visitation, that somehow these children establish some kind of a bond with foster parents and the foster siblings that they have, and along with the family pet. That's not a very wide stretch to see that happening at the age these children were at. Right now, MD is 11 and PC is 5, so that's not hard to understand. I think too much deference was given to that and superseded the appellant's rights in this case. Also, the fact that if he's coming off post-release control in June of this year, and had the appellate waited and delayed, all these obstacles, or many of the obstacles that he had in this case would have been lifted. And then he could have had the opportunity to establish a much stronger relationship with these children, and then had a much better chance of going towards reunification. The fact that he didn't ask for, he wasn't seeking reunification, that's because essentially, for lack of better words, Your Honor, with all the obstacles that you face in this case, the appellant was basically beat down in this case. He's on parole, he's got a biased parole officer who, is not going to lift restrictions, who apparently is not going to lift restrictions, and testifies in a hearing against him that for him to get his children back, which has nothing to do with the reasons of his post-release control, that's the crime that he committed, and he served his time for. The fact that he testified that it was unrealistic for the appellant to be seeking reunification, and in my opinion, that demonstrates a distinct bias against Mr. Kubik in this case, and a hearing that's really unrelated to any of the reasons for him to be on post-release control. Job and Family Services, the applicant could have waited and could have delayed filing this. If he's coming, he knew from the beginning when he's coming off post-release control, they knew that. And had he been able to get off post-release control, which would be June of this year, he could
How
have.
would that have affected the sunset hearing? Is there a statutory requirement that the children have to have some resolution of their placement within a certain amount of time?
He could have been placed with the family friends of the Normans who demonstrated in the hearing an interest, but it's apparent from what I read in the transcript that Job and Family Services, the applicant, had no interest in working with the Normans. They had already had a foster family placement, and they were going to stick with that.
But they did spend at least a couple stints working with the Normans, isn't that correct?
Some, but not at the same level of the foster parents. And considering what was happening in this matter, that you've got two parents there's a motion pending that there's going to be their parental rights to be terminated. They didn't work enough with the Normans as an alternative, okay? At least until June of 2019 of this year, to see what would happen once he comes off post-release control. Those restrictions, or most of them, would have been lifted, and that he could have had visitation, and he could have done a lot better job in working through that case plan than he was able to do, Your Honor. He was trying, and I would ask the court to take that into consideration. I think in this case, the court abused its discretion, decisions listed manifest weight of the evidence, and not in the best interest of the children. The best interest of the children is to be with a biological parent that's able to take care of them, and Mr. Kubik would have been able to demonstrate that had he given a chance. Thank you, Your Honor.
Thank you very much for the arguments this morning on both sides. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail each of you a copy of the decision on the day it's released, and the opinions are also, as you probably know, posted on the Supreme Court of Ohio's website. Again, thank you both for the arguments.